All right, let's get to the latest on that big verdict that came down yesterday, the latest in the Colin Gray case. In fact, if you were watching yesterday on 11 Alive Plus, we brought it to you live just a few minutes before 11 a.m. It took the jury less than 2 hours to come back with a conviction, and by the time it was all said and done, Colin Gray was led out of the courtroom in handcuffs, found guilty on 27 counts, including second-degree murder and involuntary manslaughter. Colin Gray, the father of the accused Appalachian high school shooter Colt Gray. This is a first of its kind trial here in Georgia of a parent of an accused school shooter. Two students were shot and killed that day, as were two teachers. And again, Colin Gray found guilty on all 27 counts. His son yet to face trial. And Colin Gray will be facing sentencing here coming up at a later date. Let's talk more now about this historic conviction in the Gray case and the big legal question of what comes next. Joining us now is John Acevedo with Emory University School of Law to break down where things go from here. Good morning, sir. Thank you for your time.
Thank you so much for having me.
Well, you're welcome. What do you make of this historic conviction yesterday?
I, I was amazed at how fast the jury came to a decision of guilty within, an hour and a half roughly. I think that shows, two things. One, that kind of jurors are fed up with these school shootings, and two, the district attorney's case was much stronger than I think a lot of us initially thought.
So if you're the defense, what are the immediate next steps? I mean, are there pretty much wide open doors for appeals here?
So you have to go back through the record and see what appeals there are to be had. Everything from did the district attorney prove their case to any motions to suppress evidence or objections to testimony. And they'll go through that to see which ones are likely to succeed and select those to move forward. At the same time, they're probably lining up character witnesses for that sentencing hearing coming up, as well as possible mitigating factors to see lower that sentence as their goal at this point.
Any reason why they wouldn't have brought those character witnesses out in the trial? I mean, when it was time for the defense to present its case, they just put the defendant on the stand.
One reason might be that they didn't have anything to say on the relationship between the father and the son, but they could talk about him in general. So they may not have been relevant to the question of guilt or innocence, but now they might be relevant to the subject of mitigation of the sentence.
What are the chances that this case on appeal could make it to the Georgia Supreme Court?
It is definitely possible. It's a new case. It's a novel theory of liability. And if you think about it this way, we hold people responsible for indirect killings all the time, reckless murder, depraved heart murder. There's quite a lot of these that we have, negligent homicide even. What makes this case unusual is that the father didn't know what the son was doing, so really wasn't a co-conspirator and was instead found guilty of kind of disregard for human life. So I would not be surprised to see this work its way up through the system, if for no other reason than it is one of the early cases on this theory.
And so, if I'm hearing you correctly, it's that second degree murder charge that could have some question marks around it, less so than the involuntary manslaughter.
Definitely, the involuntary manslaughter is much firmer ground for the DA's office, whereas that second-degree murder, it requires a higher level of culpability. The way to think about it is, the lower the charge of murder, the less we think the person is responsible for the crime. Whereas if you're at second-degree murder, that really is disregard for human life.
Well, let me ask you this. Do you think there's any pathway for this case reaching the U.S. Supreme Court?
That seems highly unlikely. The U.S. Supreme Court has tended to defer to the states for criminal conviction. There is always a chance for a writ of habeas corpus or even a direct appeal. And it's very likely those will be filed. It's very unlikely the Supreme Court would grant a hearing on those cases.
Okay, so how long could the appeals process take here? If they go through the Court of Appeals here in Georgia, I mean, we got 10 days worth of testimony, more than 60 witnesses. That's a lot of things to review, right?
It's quite a bit. They will probably have already started doing that. Typically, there's a 30 days to file the appeal. Of course, the court can take longer to hear it. So probably within a year, I would imagine you would have a final decision whether or not it's going all the way to the Georgia Supreme Court. That won't delay the sentencing. The trial court will continue on with its processes as normal as this appeal is gathered and filed.
Look, unfortunately, we have reported on school shootings before. We, in fact, had a Sandy Hook survivor on our show in the last hour talking about her experience. And here we are 14 years later talking about Appalachia. It's likely to happen again, sadly, in our country. How do you think district attorneys nationwide looked at yesterday's conviction? Do you think they're now starting to get ideas of how they might handle it in their own cities should it ever happen there?
I think they are, and more importantly, I think it makes it less fearful for them. So if you're a district attorney, you don't want to be seen as wasting money on a case or, not pursuing the easier cases to lower crime. But now that this has been done, it's much easier for them to kind of be on solid footing to try it in their own home counties. And if the voters object, they can point now to a precedent where someone was convicted.
Yeah, it's interesting. They had the Michigan case, but that was, I believe, involuntary manslaughter, and the parents went away for 10 years. Here you're looking at a gentleman who could very well go to prison for the rest of his life. John Acevedo from Emory, any final thoughts from you today?
It'll be interesting to see the sentencing if the judge gives the maximum penalty or the minimum. I think that's something that will also guide how district attorneys
Hmm.
behave. If the judge goes for the bare minimum, that might be a judicial sign that they're dubious about this. If they go for medium to maximum, then it seems like the judge themselves also felt the case was on solid ground.
Okay. John Acevedo from Emory University School of Law, sir. We appreciate your time as always. Thank you.
Thank you.